So how do you get a credit card lawsuit dismissed in the state of Florida? Unfortunately, there's no easy answer to this, but every creditor has the burden of proof to prove the case against you. They're the plaintiff, you're the defendant, it's their burden of proof. Now, the first step is that you have to respond to the lawsuit. If you don't, there's going to be a default judgment. So at that point, they don't really have a burden other than to say that they served you and you had notice. That's their burden. They get their default judgment. Now, if you respond and you have to file a response to the lawsuit with your answer, itemizing each line by line paragraph in the plaintiff's complaint, you've got to admit or deny each allegation of the plaintiff. After you've done that and you can survive that stage, then you go into the next stage of asking for documentation. Let's have discovery. What kind of papers do you have? Can you prove the debt? Maybe it's a debt buyer that you're being sued by. Well, they need to prove that they even own the account, that they purchased it from the original creditor. They need to produce bills of sales, other documentation showing a transfer. They should produce account statements, potentially a credit agreement that you agreed to, not necessarily your signature on it, but perhaps an agreement that they claim was sent to you, that you had knowledge of, that it's the agreement between the parties, because they're probably suing you for breach of contract, so they should show a contract, right? Now, if they don't have a contract, they might be just suing for account stated, which is saying they mailed you account statements, you used a credit card and you received account statements, thereby we should win based on account stated. So that can also be challenged if they're only saying that they're suing you for account stated. The point of what I'm saying is there's a lot of different ways that a case could potentially be dismissed, but it doesn't necessarily guarantee that's going to happen. It's a case-by-case situation depending on who the creditor is, who the judge is, who the opposing counsel is. Do they have the documentation? There's no magic way to get these dismissed. It's case-by-case. You got to look at the documentation. Now, should you file a motion to compel arbitration? A lot of people are saying, "Oh, just file a motion to compel arbitration. Case goes away." Not necessarily. The case is technically supposed to be abated, so it's paused while you arbitrate the case with basically a different type of court. So it's very similar to the court that we have in Florida. It's an arbitrator, a private arbitrator. You're not necessarily better doing that. So that's also not a complete way to get the case to go away. It's case by case. There's no magic sauce. You got to fight the case. You got to file an answer. Most people don't even answer. They end up with defaults. So the first step is filing a response, and consider hiring a debt relief lawyer to assist you in this.